may have had a certain amount of moral authority over his party's volunteers, these volunteers were not his subordinates when they were engaged in military operations. The Chamber has ample proof of this, including the testimony of prosecution military expert Mr. Renaud Tonens. He explained quite clearly that, on the one hand, the Yugoslav constitution and other relevant legal text envisaged the possibility of declaring an imminent state of war. Once such a declaration had been made, the army could resort to using volunteers to reinforce its regular troops. The Yugoslav armed forces were organized on the principle of unity of command. By virtue of this principle, both regular soldiers and volunteers were sent into the field and were under the same military hierarchy. On the basis of this principle, Vojislav Šešelj could not have had any hierarchical relationship to the volunteers once they had become incorporated into the structure of the regular armed forces of the JNA, VJ, and VRS. With respect to the prosecution's allegations that the paramilitary forces participated in the crimes set out in the indictment, the Chamber received evidence showing that the following paramilitary groups were in fact present during the period relevant to the indictment in some of the locations where crimes were committed, namely Arkan's Tigers, the White Eagles, the Dusan Silni detachment, the Red Berets, or the special unit of the Serbian DB Security Services, which was created on the 4th of May 1991. The Yellow Wasps, the Leva Supoderica detachment, the Vidovic, also known as Vaske unit, Gogic's unit, also known as the Loznica group, the Karađorđe unit, the SPO Serbian Guard, the Branislav Gravilovic, also known as Brne, and Slavko Aleksić units. Furthermore, the Chamber examined the alleged relationship between these groups and Vojislav Šešelj. In the Chamber's opinion, with the Judge Latansi dissenting, there is not enough evidence to find that an affiliation existed between Vojislav Šešelj and certain paramilitary groups, such as Arkan's Tigers, the White Eagles, and the Karađorđe unit. The Chamber also finds unanimously that there is no evidence of a direct hierarchical relationship between Vojislav Šešelj and the Loznica group, or the Serbian Guard unit. The Chamber further finds that Vojin Vučković, also known as Žučo or Žuca, was the commander of a Serbian volunteer unit, but he operated independently by taking on the name Yellow Wasps. Žučov's brother, Dušan Vučković, also known as Repić, and a person whose nickname was Topola, were also members of this unit. Vojislav Šešelj distanced himself from the Yellow Wasps after the murders committed in Zvornik. With respect to the Red Berets, the chamber found that some SRS volunteers had joined the units of the Red Berets and were even commanders of those units. The Leva Supoderica detachment consisted of SRS volunteers sent to Vukovar by the SIS staff or recruited locally. With respect to Vasque's unit, the chamber found that Vasque was a member from its inception and a founding member of the SRS. The chamber finds that from September 1991 to late February 1992, Vasque was an SRS volunteer in Benkovac, in Dalmatia. With respect to Brne's units and Slavko Aleksic's units, the chamber found that these units consisted of SRS volunteers in Bosnia and Herzegovina during the period covered by the indictment, but that Brne and Slavko Aleksic had not been sent by the SIS to the Sarajevo region. Nevertheless, Vojislav Šešelj acknowledged them as being the commanders of the SIS volunteers on the ground. Their units had furthermore been placed under the command of the VRS. I will now summarize the Chamber's legal and factual findings on the crimes set out in the indictment. With respect to the requirements under Article 5 of the statute regarding crimes against humanity, the Chamber, by a majority, Judge Latenzi dissenting, found that the prosecution failed to prove beyond all reasonable doubt that there was a widespread and systematic attack against the non-Serb civilian population in large areas of Croatia and Bosnia and Herzegovina, notably in the municipalities of Vukovar, Zvornik, the region of Sarajevo, and in the municipalities of Mostar and Nevesinje during the period covered by the indictment. The evidence tendered and considered in fact establishes that there was an armed conflict between enemy military forces with civilian components. The majority is of the opinion that the prosecution failed to present the judges with an account that clearly shows that civilians who did not participate in combat were targeted en masse. The prosecution does no more than make general statements that fail to account for the specific evidence heard by the judges. Under such circumstances, the majority cannot dismiss the defense's argument, amply supported by some of the testimonies, according to which these civilians had fled the combat zones to take refuge in villages inhabited by members of the same ethnic or religious group, that the buses that were provided for this purpose did not constitute operations to forcibly transfer the population, but were in fact provided on humanitarian grounds in order to assist non-combatants who were fleeing combat zones in which they no longer felt safe. In the case of Vojvodina, the majority of the chamber, Judge Latanzi dissenting, finds that this area was not a zone of armed conflict, The majority did not note any effort made by the prosecution to argue, let alone prove to the Chamber, that there was a clear nexus with the conflict in Croatia and in Bosnia and Herzegovina. The prosecution has not presented any evidence on the conditions under which Serbian refugees arrived from Croatia in order to establish such a nexus. The majority also noted other shortcomings in the prosecution's approach. The majority notes the particular weakness of the evidence presented by the prosecution to establish a nexus between the acts of violence and the departure of civilians from certain areas. The report of expert Eva Dabo merely provides a comprehensive list of the departures that occurred throughout 1992, without specifying the cause behind them. Similarly, witness VS061, upon whom the prosecution relies heavily, was not convincing. He was caught out on a number of occasions and had to admit that his account contained serious omissions and fabrications. These fabrications concerned essential issues such as the murder of a Croat, Mijat Štefanac, which, according to the witness, was claimed to be the event that made the Croats flee. Under cross-examination, he admitted that this murder had been committed in a cafe in the context of a private dispute which got out of hand, and that those responsible for the murder had been arrested and tried. The majority notes that, generally speaking, the violent acts against the civilians in Hrtkovci, such as they have been described, are not comparable in terms of their scale and modus operandi to a widespread and systematic attack against the civilian population. The testimony that has been heard, far from suggesting that there was a large-scale attack against the Croatian civilian population, rather points out acts that were based mainly on local or even private reasons. Their primary reason would appear to be the acquiring of accommodation by Serbs who had none because of their refugee status. Finally, the majority notes, and without neglecting the particularly troubling speech made by Vojislav Šešelju on 6 May, in which he clearly called for the expulsion of Croats, in particular those whom he considered to be disloyal, that it was not alleged that Vojislav Šešelj was directly involved in the exchanges of houses. Yet these exchange contracts are specified as the principal means by which the Croats were expelled from Hrtkovci. At best, the prosecution could have sought to establish that Vojislav Šešelj bore indirect responsibility, not direct responsibility, for acts of persecution. In any event, the majority notes the absence of crucial legal elements to establish any form of criminal responsibility for crimes against humanity. Consequently, the Chamber, by a majority, Judge Latanzi dissenting, finds that the conditions required under Article 5 of the statute have not been met. with regard to the requirements under Article 3 of the statute regarding war crimes, the Chamber notes: the existence of an armed conflict in Croatia and Bosnia and Herzegovina during the period covered by the indictment. 2. The crimes specified in the indictment as violations of the laws or customs of war could have been committed by members of the Serbian forces in order to support the armed conflict, or as a result of that conflict. With regard to war crimes, the Chamber notes that it heard certain evidence on crimes not alleged in the indictment. Given Vojislav Šešelj's right to be informed of the charges against him, the Chamber did not take this evidence into consideration. Furthermore, the Chamber holds that the prosecution has not provided sufficient evidence to establish that the following crimes were committed: the murders in the Crna Rijeka sector, cruel treatment in the form of forced labor inflicted on the detainees at Ovčara farm, the cruel treatment inflicted on detainees in the Velepromet warehouse, the torture and cruel treatment of the detainees in Sonja's house, in the Semizovac barracks, and at the tire repair garage at the Vogoscha crossroad in the Sarajevo region, and the plunder of private property by Serbian forces in the villages of Nevesinje municipality. The Chamber, by majority, Judge Latanzi dissenting, holds that the prosecution has not provided sufficient evidence to establish that the following crimes were committed: the murder of non-Serb detainees on the Žuč Hill near Sarajevo, torture and cruel treatment at the Gero slaughterhouse near Zvornik, and the plunder of public or private property in the town of Vukovar and its houses. The Chamber, by majority, Judge Latanzi dissenting, also did not accept the charges of wanton destruction or devastation not justified by military necessity of towns, villages, and homes, and of the deliberate destruction of institutions dedicated to religion or education. The majority holds that there is insufficient contextual information on the destruction to allow for an assessment that would take all the factors on the ground into account. The Chamber noted the existence of certain crimes, and it will provide a list of these crimes before determining whether they can be attributed to Vojislav Šešelj. In the municipality of Vukovar, murder, torture, and cruel treatment, including sexual assault, inflicted on detainees at the Velepromet warehouse and the Ovčara farm. In the municipality of Zvornik, the murder of Muslim civilians during the attack on Zvornik in April 1992. Murder, torture, and cruel treatment inflicted on Muslim detainees at the Ekonomia farm, on detainees at the Ciglana factory, on detainees at the Drinjača Dom Kulture, on detainees at the Karakaj Technical School, and on detainees in the Čelopek Dom Kulture. The murder of a large number of non-Serb detainees at Gero's slaughterhouse, torture and cruel treatment inflicted on detainees in the Standard shoe factory, and the plunder of private property from houses belonging to the inhabitants of Zvornik. In the Sarajevo region, the murder of 17 Muslim civilians during an attack on the village of Šešelju. Torture and cruel treatment inflicted on detainees in the Iskra warehouse in Podlugovi and on detainees in Planja's house, and the plunder of Muslim houses after the attack on the village of Svrake. In the municipality of Mostar, the murder of non-Serb civilians in the dump in Uborak and in the buildings of the main city mortuary in Sutina. Torture and cruel treatment inflicted on detainees in the locker room of the Vrapčići football stadium and on the detainees in Sutina. The plunder of private property from houses belonging to Muslims in the Topla hamlet. In the municipality of Nevesinje, the murder of villagers in Presjeka, the murder of Muslims in Breza and at the Kilavci heating factory, the murder of villagers detained at the Zemlje school, torture and cruel treatment inflicted on detainees at the Kilavci heating factory, on detainees at the Zemlje school, and on detainees in the SUP building in Nevesinje.
Résumer les conclusions de la
I will now provide a summary of the Chamber's findings on Vojislav Šešelj's liability for the charges in the indictment.
Circonscrit.
The prosecution holds Vojislav Šešelj responsible for the physical commission of crimes in relation to the crimes of persecutions, deportation and inhumane acts, forcible transfer, with respect to the accused's speeches, the commission of crimes as a co-perpetrator, participating in a joint criminal enterprise, or JCE, and instigation and aiding and abetting. Seeking to establish responsibility on the basis of a criminal enterprise primarily requires the identification of a common criminal purpose. If the purpose is not criminal in itself, at the very least, the crimes committed to achieve the purpose must be an inherent element. The majority of the Chamber, Judge Latanzi dissenting, has noted an entire series of shortcomings and cases of confusion. According to the prosecution, the plan for a Greater Serbia, advocated by Vojislav Šešelj, contained an implicit criminal element as a result of its aim to unify all Serbian territory in a homogeneous Serbian state comprising Serbia, Montenegro, Macedonia, and vast swaths of Croatia and Bosnia-Herzegovina, which would involve the deportation or forcible removal of the non-Serbian population. The majority has analyzed the evidence admitted on the matter in order to determine whether this definition is tantamount to a joint criminal enterprise. The prosecution lays emphasis on the transfer under Serbian control of targeted territories. This transfer was allegedly planned and included certain common characteristics such as a. Declaring vast areas of Croatia and Bosnia-Herzegovina to be Serbian autonomous regions and taking control of public institutions and local administrative bodies. B. Conscripting volunteers and coordinating the actions of the JNA, VJ, the Ministry of the Interior, MUP, TO, and other formations, and C, covertly arming Serb civilians, and D, committing crimes in the field. The majority is of the opinion that the prosecution has given a very partial interpretation of the events it claims demonstrate the existence of a criminal plan for a Greater Serbia or for an entity known by a similar name. By depicting the establishment of Serbian autonomous regions in Croatia and Bosnia-Herzegovina as actions that were part of the criminal plan for a Greater Serbia, without clarifying the broader context in which these actions were taken, namely the secession of both Croatia and Bosnia-Herzegovina, the prosecution gives an interpretation which at best hides the way the events unfolded, and at worst distorts them in relation to the evidence presented to the Chamber, which was mainly prosecution evidence. The majority considers that the plan for a Greater Serbia, such as it was advocated by Vojislav Šešelj, was in principle a political plan, not a criminal one. For Vojislav Šešelj, only the Serbian Radical Party pursued the objective of a Greater Serbia, which was to include all the Serbs, whether they were of the Orthodox, Catholic or Muslim faith. The statements Vojislav Šešelj made about his vision of a Greater Serbia do not seem to have been contested by the prosecution. Moreover, such statements can be found in numerous documents drafted prior to the proceedings in this case. Even if certain attitudes thought to be discriminatory on the Serbs are taken into account, namely the establishment of their local institutions in Croatia and Bosnia-Herzegovina, the majority holds that the totality of the evidence does not lead to the conclusion that declaring the autonomy of the Serbian people of Croatia and Bosnia-Herzegovina was the result of a criminal enterprise. In fact, it is not in dispute that Vojislav Šešelj was driven by an ardent political ambition to create a Greater Serbia. Nothing, however, indicates that there was a criminal purpose in sending volunteers. There is a reasonable possibility that the sending of volunteers was aimed at protecting the Serbs. The evidence shows that the recruitment and deployment of volunteers by Vojislav Šešelj and his party and the cooperation therein with other Serb forces, including the JNA and VJ, the MUP, the TO and the other paramilitary formations, did not constitute an unlawful activity. On the contrary, it could have been amply justified by the context of war.
En ex-Yougoslavie,
The legal framework of the former Yugoslavia allowed resorting to volunteers. These were integrated into the armed forces of the SFRY, including the Yugoslav People's Army and the Territorial Defense. Moreover, the Chamber notes that Vojislav Šešelj was not the hierarchical superior of the volunteers deployed on the ground. The above findings do not by any means presume to underestimate and even less to conceal the crimes committed in different localities in Croatia and Bosnia-Herzegovina, in which the volunteers deployed by Vojislav Šešelj or his party may have taken part or have been indirectly involved. The majority simply notes that it is not satisfied that the recruitment and subsequent deployment of volunteers implies that Vojislav Šešelj knew of these crimes on the ground, or that he instructed or endorsed them. In the opinion of the majority, these crimes cannot be considered as an inherent element of the political design of Greater Serbia or the activities aimed at protecting the Serbs. The Chamber has received an abundance of evidence establishing that the local Serbs of Croatia and Bosnia-Herzegovina were arming themselves. Nevertheless, evidence shows that Croat and Muslim civilians were equally arming themselves. In the view of the majority, this global picture gives credence to the reasonable possibility of a scenario in which all the warring factions were preparing themselves for the imminent hostilities in order to preserve the lands they considered as theirs, rather than a singular and unilateral step of the Serbian occupiers driven solely by the criminal purpose of expelling the civilians of other ethnic groups. The lack of evidence of a criminal purpose is in itself sufficient to reject the allegation of a criminal enterprise. The majority explored further, albeit superfluously, the issue of the identity of views between the alleged members of the criminal enterprise, this being a necessary element for the finding of existence of a joint criminal enterprise. The prosecution focused most of its allegations on the identity of views between Vojislav Šešelj and Milosevic, as representing the JNA VJ and the Serbian MUP, between Vojislav Šešelj and other members associated with Republika Srpska and the Army of Republika Srpska, and between Vojislav Šešelj and other paramilitary groups such as Arkan's Tigers. In its judgment, the Chamber cited the exchanges that took place between the different protagonists in the Milosevic trial during Vojislav Šešelj's testimony in that case. It appears from these exchanges that the judges in that case were as much as at a loss as the majority of the Chamber in the present case as to the object of the alleged criminal purpose. The prosecution first stated that Milosevic did not share the ideology of Greater Serbia. It was then confronted with its own earlier written submissions, from which it transpired that the notion of Greater Serbia lay at the very heart of its own case. The prosecution prevaricated, changing versions more than once, all the while refusing the adjournment willingly offered to it by the judges so that it could take its time and clarify its submissions that were found to be confusing. In the view of the majority, not only does the confusion remain, but a lot of the evidence shows that the collaboration was aimed at defending the Serbs and the traditionally Serb territories, or at preserving Yugoslavia, not at committing the alleged crimes. The Chamber, by a majority, Judge Latanzi dissenting, therefore finds that the prosecution has failed to prove the existence of a joint criminal enterprise. The Chamber, by a majority, Judge Lattanzi dissenting, also rejects the responsibility of Vojislav Šešelj in terms of the actual commission of the crimes of persecution, with all the consequences of its finding that the standards for applying Article 5 of the statute have not been met.
La Chambre
The Chamber unanimously finds that Vojislav Šešelj is not responsible for the actual commission of expulsions and inhumane acts, forcible transfer, as crimes against humanity charged in the indictment. I will now summarize the findings of the Chamber regarding the prosecution's allegations of incitement to commit crimes with which Vojislav Šešelj is charged. Firstly, the Chamber accepts that the propaganda of a nationalist ideology is not in itself criminal. It deemed, however, that it was its duty to analyze and to qualify the statements made by Vojislav Šešelj and their potential effect on the perpetrators of the crimes charged in the indictment, in the light of their context. The Chamber examined the substance and the context of several incriminated speeches by Vojislav Šešelj specifically. 1. A speech delivered on the Vukovar Road on 7 November 1991, where Vojislav Šešelj allegedly stated that, quote, "Very soon there will not be a single Ustasha left in this area," unquote. 2. A speech delivered by Vojislav Šešelj in Vukovar between 12 and 13 November 1991, where he is said to have stated that, quote, "Not a single Ustasha must leave Vukovar alive," unquote, and, quote, "Ustashas surrender. There is no need to lay down your lives anymore," unquote. 3. A speech made in Mali Zvornik in March 1992, during which he is said to have called upon his Chetnik brothers to take revenge against the Balias and push them back towards the east, far beyond the Drina River. 4. And a speech delivered on 6 May 1992 in Hrtkovci, Vojvodina, when Vojislav Šešelj allegedly stated that there was no place for Croats in Hrtkovci. The Chamber finds that the speeches on the Vukovar Road and in Vukovar were indeed made by Vojislav Šešelj. However, the majority, Judge Lattanzi dissenting, could not rule out the reasonable possibility that these speeches were made in a context of conflict and were meant to boost the morale of the troops of his camp, rather than calling upon them to spare no one. The Chamber, by a majority, Judge Antonetti, that is to say myself, dissenting, also finds that Vojislav Šešelj did indeed deliver the said speech in March 1992 in Mali Zvornik, even if it considers that the precise circumstances of the speech have not been established. The Chamber, by a majority, Judge Lattanzi dissenting, was nonetheless unable to find beyond all reasonable doubt that in calling upon the Serbs to cleanse Bosnia of the Pogani and the Balias, Vojislav Šešelj was calling for ethnic cleansing of Bosnia's non-Serbs. The majority, in fact, believes that the evidence supplied by the prosecution is not sufficient to exclude the possibility, in view of the context, that in making this appeal, Vojislav Šešelj was rather participating in the war effort by galvanizing the Serb forces. The chamber, by a majority, finds, Judge Antonetti, that is to say myself, dissenting, that the statements made by Vojislav Šešelj in his speech in Hrtkovci constituted a clear call for the expulsion or forcible transfer of Croats from this locality. Nevertheless, the majority, Judge Latanzi dissenting, is of the view that the prosecution failed to show that this speech caused the departure of the Croats or the campaign of persecution alleged by the prosecution. The chamber, by a majority, Judge Antonetti dissenting, finds that two other speeches delivered in the Serbian parliament on the 1st and the 7th of April 1992 constituted clear appeals for the expulsion and forcible transfer of Croats. In the first speech, on the 1st of April 1992, while debating a draft law on refugees, Vojislav Šešelj stated, I quote, "We are going to expel the Croats, exercising the same right that Tudjman exercised to expel the Serbs. We are not going to resort to genocidal activities, because it is not in the blood of the Serbs. We are not going to start killing you, of course. We are simply going to pack you into trucks and trains and let you get on with it in Zagreb." End of quote. The second speech of 7 April 1992 reiterates substantially the same. Even though, in the view of the majority, Judge Antonetti dissenting, these speeches were appeals for expulsion, a different majority, Judge Latanzi dissenting, holds that these statements, forming part of an opposition to the official Serbian policy, were an expression of an alternative political program that would never be put into place. The prosecution did not offer anything to show its impact. The lack of any measurable impact, combined with the certainty that the appeals to Serbians to use reprisals against Croats were never favorably received, do not allow the majority to find that there was incitement to war crimes, even when taking into account the most virulent speeches, such as the one in Hrtkovci and those delivered before the Serbian parliament. The chamber, by a majority, Judge Latanzi dissenting, therefore finds that the prosecution has failed to show a causal link between Vojislav Šešelj's speeches of the 1st and 7th April 1992 and the crimes committed in April 1992 in Mostar, Zvornik and the Sarajevo area, or that Vojislav Šešelj could be held even indirectly responsible for the crimes committed between May 1992 and September 1993. Under these circumstances, the majority is unable to qualify Vojislav Šešelj's speeches of the 1st and 7th April 1992 as physical acts of incitement. The chamber, by a majority, also rejects the prosecution's allegation of incitement to crimes on the basis that Vojislav Šešelj failed to take steps to punish the Šešeljevci who had taken part in crimes against non-Serbs. The majority recalls that no formal or de facto hierarchical link was found to exist between Vojislav Šešelj and the volunteers involved in the crimes charged in the indictment. Failure to punish, however, cannot be invoked in the absence of any hierarchical link that would make Vojislav Šešelj responsible for the volunteers' conduct. In the view of the majority, it is established that in terms of their actions on the ground, the volunteers were under military authority. With regard to the alleged responsibility of Vojislav Šešelj on the count of aiding and abetting, the Chamber by a majority, Judge Latanzi dissenting, rejects it, noting that the underlying allegations of the prosecution have the same factual basis as its allegations on his responsibility under the joint criminal enterprise and incitement. I will now read the disposition. For the reasons summarized above, the Chamber rules as follows. On count 1, persecutions as a crime against humanity, the majority, Judge Latanzi dissenting, declares the accused not guilty. On count 4, murder as a violation of the laws and customs of war, the majority, Judge Latanzi dissenting, declares the accused not guilty. On count 8, torture as a violation of the laws and customs of war, the majority, Judge Latanzi dissenting, declares the accused not guilty. On count 9, cruel treatment as a violation of the laws and customs of war, the majority, Judge Latanzi dissenting, declares the accused not guilty. On count 10, expulsion as a crime against humanity, the majority, Judge Latanzi dissenting, declares the accused not guilty. On count 11, inhumane acts, forcible transfer, as a crime against humanity, the majority, Judge Latanzi dissenting, declares the accused not guilty. On count 12, wanton destruction of villages or devastation unjustified by military necessity as a violation of the laws and customs of war, the majority, Judge Latanzi dissenting, declares the accused not guilty. On count 13, destruction or willful damage done to institutions dedicated to religion or education as a violation of the laws and customs of war, the majority, Judge Latanzi dissenting, declares the accused not guilty. On count 14, plunder of public or private property as a violation of the laws and customs of war, the Chamber unanimously declares the accused not guilty. With this acquittal, on all the 9 counts of the indictment, the arrest warrant issued by the Appeals Chamber on 17 June 2015 is hereby rendered moot. Following this verdict, Vojislav Šešelj is now a free man. Judge Antonetti provides an assenting opinion. Judge
L'audience est
Judge Nyan attaches the declaration. Judge Latanzi attaches a partially dissenting opinion.